Hi, this is Aaron Lacey. You're listening into M&A in Higher Education, Considering the Letter of Intent, which is a webinar that's being put on today by Thompson Coburn. We're a law firm with offices all over the place, some in the east, some in the west, and this is part of our higher education webinar series, so we're glad you're attending. If you're on the East Coast, I like to say good afternoon, and if you're out west, good morning. And if you happen to be in the Carolinas or Georgia, I hope you're finding your way to somewhere safe. Some housekeeping just to start off at the top of the hour here. Again, thanks everybody for attending. This webinar, like all of our webinars, is CLE accredited. If you're a lawyer, you know that means continuing legal education credit. It's CLE accredited in California and Illinois for an hour, and in Missouri for 1.2. There are going to be 3 pop-up engagement polls during this presentation. You'll see them if you're watching the presentation. They'll pop up, and you have time there to just click and show that you are, in fact, engaged. And you'll need to do that to make sure that you get your CLE. It's a little different from last week, and it's easier. So, or I should say 2 weeks ago, if you attended our first webinar in our higher ed webinar series, we had little questions that came up. This will actually be easier. All you have to do is note that you are engaged. There are some widgets down at the bottom of the screen you'll see. They are resizable and movable for your convenience, and they all do different little things. For example, if you have questions during the webinar, you can submit them through the Q&A widget. And by the way, please do. We're not going to answer questions during the webinar, but we will try to get to as many of them at the end. This webinar is timed for an hour, and we hope that the content will all be delivered in the hour. That's the plan, but if we have Q&A that goes over, we'll stick around and answer the questions in the time that we've got, and stick around and answer as many as we can. Also, I'll note in the resource list widget at the bottom, you can access a copy of the slide deck. So if you'd like to download a copy of the slides, you can do that right now. For the best viewing experience, we recommend using a wired internet connection if you got one. Some networks, by the way, also cause our slides to advance more slowly. If you're finding that your slides are behind, try pushing F as in Frank 5. Finally, an on-demand version of the webcast should be available free within about 30 minutes to an hour following the webcast. This is a relatively new platform for us. We talked about it a little bit last time. We're very excited, and one of the great upgrades is that we can provide you that on-demand capability very shortly following the live webcast. Finally, a survey is available in the widget at the bottom of your screen, and we always value your opinions and appreciate if you will give us your feedback. We really do read that, and we really do try to make every webinar better than the one before. So with all of that having been said, let's move on. I do want to just highlight again, this is part of our higher ed webinar series. We've got one coming to you each month. We'll be posting things on the blog and sending things out regarding upcoming webinars, and you can register for them if you have an interest. We did student litigation last month, and that is available on demand if you have an interest. And next month, I'll highlight in advance of the November midterm elections, we're doing a webinar on higher ed in the November elections, which I think will be very interesting. We've got a couple of the lobbyists in our D.C. office who do higher ed work who are going to be leading that. If that is the kind of thing that interests you, I encourage you to tune in. Take a minute now. I'd like to introduce our 2 presenters for today. The first, Emily Murphy, is a partner in our corporate and securities practice. I have worked with Emily for many years, even before we both ended up here at Thompson Coburn. She is a friend and a colleague and a superb corporate attorney. Also, she manages to somehow balance between being a hard-as-nails negotiator and one of the nicest people I know. She is great to work with, has worked in a number of post-secondary education transactions with me over the years, including for-profit to for-profit and conversion, so cross-sector negotiations, and has a lot of experience, not just as an M&A attorney, but in particular in higher ed, and as a consequence will be offering a lot of great expertise and insight today. Katie Wendell is another individual that I've worked with for many years. Katie, like me, is an education regulatory attorney, also does a lot of work in the merger and acquisition space, or has over the last decade and a half or so. And also a delightful person. So today, Katie, along with Emily, will be lending a lot of her experience and insight, not only just from sort of a transactional perspective, but very specifically, thinking about transactions in this highly regulated space that is higher education. So with that, I'm very pleased to turn it over to Emily.
Aaron, thank you so much. I'd like to extend a warm welcome and thank everyone for joining us today. As Aaron said in his remarks, he, Katie, and I work together closely here at Thompson Coburn, and the most rewarding part of our jobs is helping clients get where they want to go. So today we're excited to take you on a journey through the world of M&A, which is short for mergers and acquisitions, and in particular the letter of intent, or the LOI, a key document in the process. This seminar is focused on transactions occurring in the higher education space, so we will point out things that make school deals unique and distinct from general corporate deals. Our presentation is organized as follows. First, we'll take a quick look at the lay of the land. We'll walk through the current regulatory environment as well as the U.S. economy and changing demographics, as those factors explain the increase of transactions among schools. We'll also talk briefly about what we're seeing in the marketplace in terms of attractive deals that are gaining traction and providing benefits to all parties. In part two, I'll go over the general M&A process so that we all understand where we are and where the LOI comes into play and its role throughout the process. The LOI might be a short 5 to 10 page document, but it's the first flag in the ground, if you will, and really lays the groundwork for the events to come. We'll then spend the bulk of our time dissecting the LOI and terms typically covered within the four corners of those pages. As you might imagine, many terms are similar to any other transaction, such as purchase price or closing date and post-closing transition matters. However, in higher ed deals, there will be regulatory considerations that will impact not only the structure of your transaction, but also the timeline and actual closing date of any merger or sale. Finally, Aaron will highlight the resources available to you from Thompson Coburn, and we'll reserve some time at the end for Q&A. So as he said, please feel free to send in those questions as they come along, and we'll get to them together at the end. So let's go right to a current snapshot. So in some ways, it's a great time to own and operate a post-secondary institution. We have a lot of clients and institutions who are doing very well. There's a robust U.S. economy right now. There's a favorable administration with a much friendlier regulatory environment than the Obama-era regulations. We're watching those being repealed or toned down. We've seen a lot of interest from strategic buyers and institutions abroad. So there's a lot of infusion of capital and acquirers coming in from across overseas. The only thing I'll point out about that is sometimes it can be tricky to let people know from abroad, the regulatory web that exists here in the United States. Just as I actually have a client here who's interested in expanding into Asia, and so, we don't really have any sense of the regulatory environment in Asia. So, and also programs in schools are available at attractive price points, and so that's leading to an increase in transactions. Some other things that are out there in the marketplace, we have just general population numbers. There's changing demographics of students. We see there's lower enrollment in white students and more students of color starting to go into these secondary schools. And also, ironically, we are watching international student enrollment drop. And so that's kind of a challenge since those students were really providing, paying full freight and really helping with the finances of U.S. institutions. And finally, some schools out there are struggling with just general financial issues. They could be in a bit of distress or, maybe taking on a bit more debt than is advisable for a healthy balance sheet. So all of that just goes to say that we do see higher ed mergers taking place, and we expect it to increase in the future. I'll let Aaron here go through some of the trends that he's seen in the marketplace.
Yeah, and thanks, Emily, and this follows up on a little bit of what Emily was just saying a little bit. But, when we were contemplating this transaction, and we don't want to spend too much on this. In fact, I'm going to go through this fairly briskly because we recognize a number of the people who are on today work in the space or have had experience with mergers and acquisitions already in higher education. But we thought it was worthwhile just talking a little bit for a moment here at a high level as to sort of why we're seeing the activity we're seeing. And again, Emily spoke to some of that, and I wanted to just add a couple of comments. Why are institutions pursuing mergers and acquisitions and other transactions? To Emily's point, I'm really seeing in my practice, and we've talked about this, a couple of three different things, but most of the drive I'm seeing is coming from the idea that there are a lot of institutions at this point who are experiencing some level of distress. That may not be significant distress, it may be mild, but they're trying to figure out, at least at some level, what their long-term business model or strategy is. Many of these schools, nonprofit, for-profit alike, have a lot of very attractive elements about them, right? Their programming, their platform, their faculty, staff, they have geographic locations in desirable spots. But because they are struggling, they are at this point willing to entertain an investment or a merger opportunity, and as Emily said, a fairly favorable price point. At the same time, there are other folks out there who are doing very well, institutions, there are investors who are returning to the space and are interested in investing in higher education, and there are folks overseas, and so they see an opportunity here to potentially acquire this platform or make this investment at what would be potentially a fairly discounted price. So you've got folks on one side who are in need but have something attractive to offer, and then on the other side you've got folks with capital who have, for whatever reason, some sort of vision or strategic plan, and they think a merger or an investment or an acquisition could help advance their mission and their cause. So there are a lot of different variables at play, but at a high level, that's what we're seeing driving a lot of it. At the same time, and Emily and I were talking about this yesterday, at least among for-profit and career schools, you don't see this as much on the nonprofit side, but among for-profit and career schools, we are seeing, in some cases, sole proprietorships or family-owned businesses where baby boomers who started these schools 30 years ago or 40 years ago are just ready to retire and get out of the space, and that may mean they want to sell to another for-profit entity, or depending on the nature of their school, it may mean that they have an interest in trying to find a nonprofit and essentially allowing their educational operation or institution to sort of merge into and become part of an existing nonprofit and then be governed by a board and sort of self-perpetuate under that nonprofit model. But they're looking for an exit strategy. Finally, one of the things that we're seeing quite a bit of, and this tends to make the news because I think it's such an interesting concept, are these cross-sector transactions. In the 2000s, there was a point in time, and Grand Canyon's a great example of this, Ashford University is a great example of this, where for-profit institutions or investors were acquiring nonprofit entities. And now what we're seeing is a trend in the other direction where a number of for-profits are either being acquired outright by a freestanding nonprofit. I'll note, for example, the Purdue acquisition of Kaplan is a great example of an existing, well-established, in that case, public university acquiring a for-profit platform. But we're also seeing examples of for-profits that are trying to find a nonprofit partner so they can convert into that nonprofit space. And I think the motivations for those conversions are complicated and vary. But from a legal and transactional perspective, it's fascinating, right? Because what you're seeing is this cross-sector transactional work that's occurring. Why do these transactions make sense? I mean, I sort of commented on that earlier, because for those with capital, this is an opportunity to expand, to grow the platform, to create new applications or to acquire expertise in the form of faculty, staff, et cetera, and at a very favorable price point. And for folks who potentially are in distress, this is an opportunity, sort of an exit strategy to evolve their institution to its next level and maybe be successful as part of a larger or different entity. And we talked a little bit already about sort of what makes this interesting. I think those go together in terms of the hot ticket items and valuable assets, platforms, programs, faculty, staff. But, the last question on the slide here, why do some transactions fail? And you do see in the press, I think, conversation often about large nonprofit mergers that don't work out. Those who are in the space, the brokers or intermediaries on the phone know that. There are also, on the for-profit side, smaller transactions that don't work out. They just don't make the news. And I think the reasons for that are often and similar. Some of them are economic, but I will suggest in higher ed, one of the things that's a real challenge is cultural and operational integration. It's not just a widget factory acquiring another widget factory. I mean, these are large, complicated organizations. You've got, in the nonprofit context, faculty senates and buy-in, shared governance to contend with. You may have decades and decades of history and brand identity, alumni who feel very strongly about the organization, and successfully identifying a partner and carrying out an integration of all of those components and ideas and getting approval, through the shared governance structure is just an extraordinary challenge, right? It's not, for obvious reasons, it's just not like having a sole proprietorship merge or sell to another sole proprietorship where you have 2 or 3 people making the decisions. So they're complicated and they're challenging, and the bigger and the more complex the organizations, typically the bigger and more complex the challenges. But they are happening, and there's a lot of reasons that they're happening. And for those folks in the space, it's a very exciting and interesting time. Emily, back to you.
Thank you, Aaron. I appreciate that. Very helpful insight. So in this second section, then we'll go over just very briefly again, the kind of bones of a corporate transaction, so that we can understand where the LOI fits in terms of where we are. And also, our future webinars will cover other parts of a corporate transaction. So, it's interesting. So for any M&A transaction, you'll see we've got this fantastic rainbow caterpillar for you here and showing you the steps of how it begins with negotiations and discussions. You'll see that our LOI, our critical document, is step 2. And then, going along the way, the parties conduct due diligence to make sure that they're a good fit. They negotiate all of those little details and prepare agreements, and those are binding commitments to merge or to acquire a school. Then the regulatory folks kick in and make sure that all of those consents and approvals are secured before we can close. Then after we close, the ownership or the merger actually consummates. And thereafter, we do have some post-closing matters that we address from time to time, operational issues, getting 401ks transferred over, things like that. So, one of the things that's interesting to me, I'm a corporate attorney by trade, but I've been working in the regulatory space for, 15 years or so. On the corporate side, the board of directors of a corporation is responsible for maximizing value and for getting return for their shareholders, in other words, the owners. The board of directors or the trustees or the president of an institution, I think, has a lot more kind of cooks in the kitchen. So not only do they have to satisfy the owners or the stakeholders, you've got faculty, you've got students, you've got a lot of constituents that you need to serve, and you need to make sure that a transaction would be in all of those parties' best interests. And so problems can arise when a transaction is in, perhaps the owner's best interest, but not necessarily the faculty or the staff. So, and the other thing I wanted to say about M&A, and Aaron touched on this briefly, is, I realize some of you do this for a living, and some of you may have never been through one. So I'll leave it to you to judge whether, my client said to me after I closed an ed tech deal, she turned to me and said, "You are absolutely crazy to do this for a living." So I will leave it to you to decide if this is crazy, but it's an interesting process. It's always exciting. Third parties that we can't control, regulators. I mean, you never know what's going to happen. So always hope for a successful outcome, but sometimes it's not meant to be. But if you do not reach closing, it's not necessarily a bad thing. This sort of process can be a very helpful fact-finding mission for an institution to determine whether a strategic partnership is a good idea, or if they need to just make a few fine-tunes within the institution and continue as is. So, and remember the rainbow caterpillar. We're going to come back to this. Oh, sorry. All right, and so very quickly, I thought I would just cover some terms just to make sure that we are, not just throwing around acronyms. Mergers versus acquisitions. What are the differences? So, in the higher ed space, we talk about mergers. That's just the vernacular that the parties are used to. But typically in a merger, we have two parties that are coming together to become a surviving unit, and both boards stay in place and the leadership is kind of everyone's staying on. In an acquisition or a sale, there's one institution that is acquiring either the stock or the assets of another institution and essentially taking over control of that entity. So you'll see those common transaction structures there in front of you. Also, an auction is, starting to pick up traction. That is where an institution may be put up for a bid process and may receive proposals for acquisition of assets or stock, and then and that can be very favorable to the selling institution to get the best deal that they can for their school. So you'll see that the end game here is to have an outcome that is greater than the parts. Sometimes there can be strength in numbers, and I mean that in terms of enrollment. When you have a larger student body, you can weather downturns or distressing times better. You can certainly improve your efficiency by running operations more smoothly or sharing back-end resources. The goal, of course, is to continue the educational legacy and the mission of the founders of the institution. First and foremost, I think you must serve the students and protect the faculty, and then, of course, you want to make sure that you navigate the regulatory requirements because, regulatory can certainly put a hard stop to any transaction if it's not managed well. So here I will go very quickly through the benefits of a merger. It can be a faster way to grow a school than through organic growth, meaning just trying to market to more students and increase those enrollment numbers. It could be a great way to add a new branch or increase your geographic footprint. However, I would mention here, you should caution, when you're adding a new state or a new area of the country, you might be adding to that regulatory web for yourself. So make sure you have your experts like Katie and Aaron on the case. And we've seen a lot of interest in adding on, whether it's an online program or a law school or a pharmacy school. So it's just a great way to just instantly bring your enrollment numbers up and have a brand new offering that could be very attractive to students. We do see some reluctance or hesitation by the leadership. It's hard sometimes if you're a distressed institution to give up, this identity that you've created for yourself. I mean, I'm thinking of an acquisition, or actually it was deemed a merger in Pennsylvania, and it was a boys and a girls school. They were sister-brother schools, but the male alumni were very upset that the girls' name came first. So I understand, the identity issues are very important to these schools. But, first and foremost is to maintain the institution, keep the mission going, and keep serving the constituency. So the only reason I mention that is because, one of the critical things to think about as an owner or a president or a trustee of a school is to think about clock management, because a lot of leaders want to hold out as long as they can and keep going, even if the financials aren't as strong as they could be. Do not think of M&A as a last resort. If you run out of rope, your leverage may decrease, and you could be facing closure if a transaction is unsuccessful. So don't get too far down the path. I mean, I think the role of a good owner and a good leader is to keep all of your options open so that you could, continue, your options would be continuing as is and trying to grow organically through enrollment, or, pursuing a strategic transaction with a good partner that would be a good fit, or it could be the closure route, which is what we all want to avoid. Okay, so now that we've gotten kind of the corporate housekeeping out of the way, I'll spend a little bit of time why we're all here today, which is dissecting the letter of intent. As Aaron mentioned, I mean, the letter of intent is pretty much put together after a deal has been struck, almost like a cocktail napkin deal. And it's really so important because it serves as the blueprint and instructions for all of the parties who are going to help work together to get this transaction done. So here on this slide, you'll see we talk a little bit about how is a deal consummated or created. So it could be a handshake deal. You could have presidents reaching out to other leaders to discuss a potential strategic partnership. There are professional brokers in the space who act as a matchmaking service to put organizations together that would be a good fit. There are also geographically close or similar institutions, such as public institutions that would benefit from sharing resources and reallocating, whether it's staff or back-end services. So once that deal is struck, then the next step would be negotiating the letter of intent. So this is the first document that's put together, and ideally it's short. It's not going to include everything. It's impossible to include everything in the letter of intent, but you want to have the bare bones of the transaction set forth. What's the purchase price? Are we doing asset or stock? What's the surviving entity? After all of those types of big picture, maybe your top 5 points are covered, I suggest that you start to put this down on paper and then bring in your attorneys. After, as you all know, regulatory is a huge part of this, and it's a huge part of the success of a transaction. So it's best to bring in your advisors before you sign an LOI. And sometimes our clients bring us signed LOIs, and that's okay. But a couple of pitfall, maybe recent issues that I saw when I wasn't involved in the drafting of an LOI was there was no termination date. So it was just kind of like you could never get out of this LOI because they hadn't thought to put an end date to it. So that was kind of, not ideal. Another one had an earn-out provision, and, we won't talk about earn-outs here. That could be an entire webinar itself. But, an earn-out provision that was tied to the performance of the school after the closing. But it was, those are tough to draft. So when folks try to draft those and it's not clear and, there's not a meeting of the minds, you can run into problems there. So I think the advice is have a clear LOI, make sure everybody understands what the end game is going to be, what the goal is, who's responsible for what, so that we can get through this and make sure that we're all, kind of rowing the boat towards the same closing date. Okay, and so this next slide, I wanted to focus on confidentiality and exclusivity. Those two terms are typically the binding terms of an LOI. The other terms in an LOI, such as purchase price, everything else is typically non-binding. So what that means is that in terms of confidentiality, meaning, and ideally you have an NDA in place because confidentiality is hard to cover in one paragraph. If you have a non-disclosure agreement in place, then the parties can exchange information and make sure that, financial data, enrollment numbers, other things like that are not disclosed to the public, but just kept among the parties and only for discussion in connection with the transaction. Exclusivity. How long do the parties have to speak to each other before other, parties, when other parties can, put in a bid, or when the seller can decide to speak to another party? So those two are the binding parts of, those are the ones that we see as binding terms. The other terms, such as purchase price, contingencies to close, they're typically not binding, although there is a good faith expectation that you will honor the terms of the agreement unless something, catastrophic happens or there's some sort of material discovery and diligence that the parties were not aware of before. So, and I'm kind of flying through this so that we can get to the good stuff, which is the regulatory at the end. So on this slide, you'll see, the other terms of the letter of intent, which are typically not binding. Who are the key employees? Who's going to stay on? How's the transition going to work post-closing? Is there going to be a non-compete? When is diligence going to be completed? There may be a paragraph about the working capital. Real estate considerations. Is there a building involved? Is there a lease? Again, the termination provision that I mentioned briefly, if talks go on for 60 days or 90 days and it doesn't work out, then, this letter of intent needs to terminate at some point. Governing law for disputes, if anything were to arise, where are we going to resolve the dispute and what law will apply? And typically expenses are covered by the party who's incurring those expenses.
Hey, Emily, this is Aaron.
Yep.
Maybe it would be worth, and again, we have sort of a mixed audience. We looked at our registration list, and we know we have some who do a lot of, have been involved in mergers and acquisitions, and others who may not have been. But maybe you could talk just a little bit about what we mean by due diligence and working capital. Working capital in particular is sort of a tricky concept, but can be really a really important piece of an LOI.
That's a very good point. Thank you. And I have all of these notes here, and I'm trying to, make sure that we use our time wisely. So thank you for that. And certainly due diligence is on my list. I think of due diligence as falling into two buckets. There's corporate diligence and there's regulatory diligence. So the corporate diligence is kicking the tires before you buy the car. Is everything in order? How is payroll looking? What's the staff look like? Is there any litigation? Just going through the company records to make sure that it's in good shape and you're buying what you think you're buying. Regulatory diligence is a totally different animal. Will be covered by Aaron and Katie later on. You need to make sure that accreditations are in place, and there's no show cause letters or any kind of other issues or red flags that you may not need to be aware of. So in terms of diligence, it's up to each client whether they want attorneys to be involved in their due diligence review, and that would be, we would look at all the contracts, we would look at all the leases, employment agreements, to see, in fact, which items would continue after closing and therefore would become a buyer or survivor responsibility. Same goes for regulatory diligence. The client could determine that it wants to conduct its own diligence, or we can be involved and assist with that as well. So in terms of working capital, this one's always very tricky, and sometimes people don't understand, or it's a very confusing provision. Certainly understand that. So there's a little bit of, I would say that the accounting for higher ed institutions is very specialized, and I fully recommend having higher ed accounting firms who are well-versed in the space assist you with this. So, because it's going to be different, right? It's not like we're selling widgets here and we're just, every time we sell 50 widgets, we get $50. I mean, that's not how higher ed works. We have student enrollment, we have federal financial aid coming in, we have student refunds, kids who drop out, tuition. So it's a very special way of calculating these things, and it's very seasonal as to when you're closing. I mean, what your working capital is going to look like. Obviously after the federal financial aid comes in, your balance sheet is going to look very flush, but everybody understands that it's the financial aid funds coming in, and that, if you're not holding summer session, there may be absolutely no, tuition coming in at that time. So working capital it's tough, and I think it depends institution by institution, what is the appropriate level for working capital. As a rule of thumb, I recommend a target working capital of, a month or two to kind of keep, the company from bouncing checks. But certainly this will take a lot of weigh-in from the parties as well as the accountants.
And working capital, in the most basic sense, how would you describe that concept? Well, the amount of money that's in the institution at the time the transaction closes and is consummated?
That's exactly right. So what happens is, I think of it as a checking account for the institution. So you've got, the federal, whether you've got tuition or federal financial aid coming into your checking account. You've also got faculty to pay and, expenses to run and leases and all that kind of stuff. So you need to have a certain amount in the account, literally so that the checks don't bounce and that the institution can continue on in its operations. So, I have to tell sellers sometimes, I realize that you've got $50,000 or $100,000 in checking, but you can't take that with you when you sell the institution. So, or, it could be negotiated. Target working capital could be $0. But, it's all up for negotiation. But to your point, Erin, it's really critical that the parties understand what's coming, what's going, what's staying behind, and, what am I getting and what will be there? Will I need to infuse capital immediately the day after closing? All of these things are critical for the parties to understand. The last thing you want to do is come to an agreement and then have the seller, and by the way, I'm just going to use buyer and seller as generic terms because it's easier than, merging entity or surviving or target. But the last thing you want is for the seller to misunderstand and withdraw every penny from an account when the buyer would have assumed that the $200,000 would have been staying behind. So it's critical to get the accountants in there to understand what the working capital is, historically, what's been the seasonal flow of it, just to make sure that the institution is well funded. And, and you'll talk a little bit later about passing those, same day financials tests and a lot of those ratios and reports that are very important to Ed.
Exactly. I'll also add, too, for folks who may not have as much familiarity, a lot of times the parties will agree, and this will be spelled out in the LOI, to this idea that a certain, Emily mentioned the phrase, a working capital target. So in other words, the parties will agree that at the time the transaction is consummated, there will be a certain amount of money in the institution. And we'll say hypothetically that let's just say the working capital target is 0, right? So at that point in time, there won't be a debt and there won't be a surplus. If you then have a variance off of that, then there can be an adjustment to the agreed upon purchase price. So it's really important to understand that this working capital concept can impact, if you are a seller, how much money you are actually receiving in exchange for the institution. So it's one of those things that is often spelled out in some detail in the LOI because it is integral to the purchase price.
Thank you, Aaron. All right, and so I will go to the next slide, which I felt that conditions to closing deserved its own slide, and you'll see here the Simpson family asking, are we there yet? So when you're the corporate attorney, you often are kind of herding cats and getting everybody to the closing date. So closing conditions. You may recall, if you go back to the Rainbow Caterpillar, you've signed the LOI, you have done your diligence and your negotiations, and now you've signed an agreement to merge or acquire a program. And so now you're in an executory period where the regulatory folks are doing their work and, you know, calling the agencies and the states and Ed to get those regulatory consents in place so that we can close. So that's what I mean by closing condition. It's, you know, we have a binding agreement to purchase or merge, but we can't close yet because we still have to get some consents and some other things here you'll see. So here I wanted to, you know, so closing conditions is a big part of the LOI, and a lot of times the parties negotiate exactly what will be a closing condition. Buyers love to see schools in tip-top shape, so, you know, they'd like to have a diligence condition in there saying diligence is all completed and it's satisfactory. They like to have financing lined up so the buyer doesn't have to close if its bank loan doesn't come through and the acquisition line isn't there. Of course, regulatory is, you know, required by law. You cannot close before you have those regulatory consents in hand. And there may be other required consents from third parties. I don't know if it's, you know, you've got some contracts, servicing agreements, or landlords that require consent before for a change of ownership. So, so generally speaking, you know, buyers like to see a lot of different conditions so that the school is in tip-top shape, and it's just minimizing your risk, right? Because if you get all of these conditions met before the closing, you have a very good chance that you're going to operate this institution without any issues whatsoever because you've already checked the boxes before closing. For sellers, the perspective is a little bit different. They like to just list the required consents, you know, required by law before closing, meaning, you know, you can't close without Ed. So, you know, those types of closing. But they don't like to have all of these different conditions so that, you know, closing drags on and we're still waiting for this third party and the seller's just kind of hanging out there. So that's kind of the general corporate overview of how we make the sausage. So I will let Aaron and Katie take over from here. Aaron, maybe you'd like to talk a little bit about the considerations from a regulatory perspective for the LOI.
Yeah, absolutely. And then I will get out of the way. Katie, you're being very patient. I appreciate that. Yeah, Emily mentioned earlier that sometimes when folks, by the time we get involved, the LOI is already in place, and that is what it is. There are some very unique ideas surrounding transactions that involve institutions of higher ed, and ideally if you've got counsel, whether that's us or anybody else, who understands what's special about these types of transactions, some of this will be thought through and incorporated into the LOI. It can be problematic if parties that don't have familiarity with some of these concepts or attorneys draft LOIs and they get signed up and none of these ideas have been thought through. I mean, you can always negotiate them when you get around to the actual purchase agreement, but it just means you've got some pretty key concepts that haven't actually been considered and agreed upon. So what do I mean by the, you know, so what's special about these higher ed transactions and what are these key concepts? So almost all, not all, but most institutions of higher education, certainly many, participate in the federal financial aid programs, which means that they are accredited, but also dealing with the U.S. Department of Education, right? And the Department of Education, like every one of these regulatory entities, so a large, complex institution of higher ed could literally have scores of regulators, programmatic accreditors. If they operate in multiple states, they may have state authorizations from various different entities. They could have state board certifications, like from a board of nursing. I mentioned earlier, like a programmatic accreditation. And then they're going to have their primary institutional accreditation, and if they participate in the federal financial aid programs, their relationship with the Department of Ed. And this, of course, doesn't even get into VA and Workforce Investment Act and all these other different types of funding agencies or programs a school might be involved in. Every one of these entities is typically going to have its own process for determining, first of all, whether the transaction that's being proposed constitutes a change of ownership, but then also for securing approval of that change of ownership. And as Katie's going to discuss later, those processes can vary, and you know, what they think about what's required to get those approvals can vary. The U.S. Department of Ed is one of, for obvious reasons, the biggest. Even public entities these days, certainly private nonprofits and certainly many for-profits, all rely very heavily on their participation in the federal financial aid program. So theoretically, if you were to consummate a transaction and then the U.S. Department of Ed did not approve that transaction for one reason or another, your buyer would be very unhappy, right, as would probably your seller, because the school would no longer have access to federal aid, and that would almost certainly be highly problematic. So you want to work through this process with the feds, and you want to understand exactly what their requirements are. They approve transactions, changes of ownership or control, officially after the consummation of the sale. So what that means is, if you are an investor or an institution that's acquiring another entity, you can't know for certainty that the department will actually approve the transaction until after the transaction is consummated. But understanding that's problematic for organizations going through changes of ownership or control, the department many years ago put into place a process that's called a pre-acquisition review. And so what they essentially allow parties to do, to institutions, is to say, this is what we want to do. What do you think, department? And this is before the transaction actually occurs and takes place. And the department will evaluate various things. One of their hard and fast rules as part of this process is that if the new owner, whether that be an institution or an outside investor, it does not matter, if the new owner doesn't have 2 years of audited financials that they can provide to the department, then the department may impose, after the sale, as a condition of approving the sale, merger, acquisition, a letter of credit on the new owner. So after the sale, you would, as a new owner, have to post a letter of credit in the department's favor if you wanted the department to approve you to continue participating in the federal financial aid programs. They may also impose growth restrictions. A letter of credit could be many millions of dollars, depending on the size of the institution, because it's usually a percentage of the institution's Title IV revenues. Growth restrictions could mean that before you could, over a certain period of time, you're not permitted to roll out any new programs or any new locations, and also require that before certain other things are allowed, you have to get approval from the department. So these are serious considerations. What all that means is, before two institutions put into an LOI how they want a transaction to be structured, is it a stock acquisition or an asset acquisition? Are we going to have a new subsidiary of some existing institution that's going to actually acquire the assets? You know, corporate attorneys have all those boxes and lines, right, that show where the entities are. When you're figuring out how you want to structure the transaction and who's going to buy what, it's important to know these rules and to understand whether or not a certain structure would potentially result in a letter of credit or growth restrictions after the transaction. And alternatively, if you could structure the transaction in a way that would avoid those requirements. So this is a really important thing to understand up front, and it's something that you want to think about and then build into your LOI, because your LOI is going to typically include those sort of fundamental ideas about who's buying what and how things are going to be structured. The other thing that's really important to understand on the front end is if you're going to have any sort of regulatory realignment, We have seen, I mentioned earlier, there have been a number of transactions in recent years that have involved distressed institutions, and sort of simultaneous to working through the transaction, the institution that's selling may also be closing certain campuses, or they may want to realign, meaning they may want to change up mains and branches before the acquisition actually occurs. Those things almost always require some level of approval from a number of your regulators. And it may be that your regulators say, you know, before we actually consummate this merger or acquisition, we want to accomplish this regulatory realignment. And if you're working with the Department of Education or regional or national accreditors, that is a type of process that can take months to get through. And it's important to work closely with those regulators. And you may decide, if we don't have months, or, you know, given sort of the balance of risks involved, maybe the acquiring institution wants to simply acquire everything and do the realignment after the fact. And we've worked on transactions in the last 2 or 3 years where it's been done both ways. We've accomplished realignments beforehand, or we've worked with the regulators and they've directed and the parties have agreed that any kind of realignment or teaching out of campuses or closing of locations would occur after the transaction. And whether and how you do that places risk on either a buyer or a seller, depending on whether certain things occur before or after a transaction. So understanding some of those considerations, whether a realignment is going to be required, whether, you know, the buyer is going to take all elements of the institution they're acquiring or only parts of it, and how you're going to structure those boxes and lines to ensure, hopefully, that you satisfy the department's requirements and aren't saddled with a letter of credit or growth restrictions. All of that's really important. And they're basic fundamental concepts to the transaction, and they're things that you do want to capture in the LOI so everybody's on the same page, and hopefully so you have something that works and works well. The last bullet here, so I mentioned earlier that you have this pre-acquisition review application you can put into the department, and that's where the buying and selling institution or the merging entity say, hey, department, tell us what you think about this idea of this transaction. And then the department's going to send back a response, and they're going to say X, Y, Z. If you are the acquiring institution, the one doing the buying, what you will probably want to detail in the letter of intent is what that response has to look like, right? So this goes back to the condition to close idea. You're not just saying we have to get any required approvals, although sometimes letters of intent include language that's sort of broad and says customary approvals will be obtained. But when it comes to the U.S. Department of Education, and you're dealing with transactions, mergers and acquisitions in this space, it is often the case that a letter of intent will be very specific as to what the response from the U.S. Department of Education has to look like for the buyer to move forward with the transaction. And what that means is you need to have some understanding, you need to have counsel or someone who can help you understand what responses typically would look like and what would be reasonable for a buyer to expect. But that's something else that you're probably going to want to include in that letter of intent. Just a couple other concepts, and then I will honestly and truly get out of the way, Katie. Timing to close, it's important, and this is one of those sort of, again, idiosyncrasies for higher ed transactions. Typically, you want to try to consummate that transaction in the first 10 days of a month, and that's because the Department of Education, U.S. Department of Ed, requires the parties to provide a number of things, or the new buyer, I should say, to provide a number of things within a certain amount of time following the consummation of the sale. And specifically, they have to, the new buyer has to provide these things, and one of them is an audited same-day balance sheet, by the end of the month following the month in which the transaction is consummated. So if you complete your sale at the end of October, right, say you consummated the transaction on October 30, you would only have until the end of November to produce all those required approvals in your same-day audited balance sheet to the department. And could be a tight time frame, 35 days or so. On the other hand, if you close the transaction on October 1st, now you have almost 60 days to get those required approvals. So for an acquiring institution, in order to maximize the time frame in which they can get those approvals and get that audited same-day balance sheet done, you don't put too much pressure on your auditor, you try to close a transaction in the first 10 days of a month. And typically regulatory attorneys who do this kind of work will make an ask in the LOI that the transaction has to close in the first 10 days of any month, or it bounces to the next month. And then finally, without getting into too much detail, I'll just say there are a number of accounting concerns. I talked earlier about having that the tiers audited financials after an institution completes an acquisition of another institution. The U.S. Department of Ed is going to, I mentioned, require same-day balance sheet, and they're going to run a couple of tests. It's not the composite score test. This is often a point I find of confusion. The department isn't going to calculate a new composite score based on your same-day audited balance sheet, right? What they're going to do is they're going to run a couple of tests they call the asset test and the tangible net worth test. And if you don't pass both of those, I should say, if you don't pass both of them, then again, the department may impose a letter of credit. So it is often wise to retain, in this case, there are certain accounting firms out there that work with institutions of higher education on a regular basis in the transactional context, and they can help the folks understand, they can look at what you plan to do, how you're structuring your transaction, and they can help you understand whether or not whatever you're planning to do is likely to result in a same-day balance sheet that passes those two tests. And if not, if it's a highly leveraged acquisition for some reason and they think that you're not going to fail, then you can bake in to the acquisition price some consideration for the fact that you're going to have to post that letter of credit on the back end after the sale is done. So again, these are ideas that are very specific to higher education and transactions that involve the U.S. Department of Education. And even as early as the LOI stage, it's important to be thinking about some of these things. And if you can, if you're a buyer or a seller, trying to protect your position in that LOI. With that, Katie, I will finally get out of the way.
Erin, I have all afternoon, so I am fine. I am fine listening to you talk about this stuff. It's fun for me. So I am going to talk a little bit more in depth on some of the regulatory considerations, which Erin did touch on a little bit, of course, because it all is so intertwined. But, of course, all of these things depend on the type of deal and who the parties are, what kind of situation you've got. But the Department of Ed will be at the top of that list, but both sides need to really think through what agencies are involved, and Erin kind of went through who some of those agencies are, but of course you certainly don't want a deal held up way down the road because you're missing an approval from the Nebraska Board of Massage Therapy. So it's just good to have a preliminary idea of who those agencies are, and then also a determination of what will be required. So some agencies, of course, don't need anything. There's nothing in their regulations, or they don't have rules set up to deal with this sort of thing, so they just might want to notice. Although we are seeing that most agencies do now have something in place and a procedure that they expect because so many schools have undergone a transition like this. So they might want an approval, or they might request that you send them the letter of intent once it's signed. They might want to know the structure of the organization later on. So those kinds of things. It's just good to know what you might expect from those agencies, and then be able to factor that into your timeline. For letter of intent considerations, of course, you'll want to consider whether approvals with these agencies, as Erin mentions, you might need a realignment, or some of these approvals might be so crucial to your moving forward with the institution that they would need to be something added into the LOI. So you'd want to draft a clause depicting exactly what you need and what needs to happen moving forward. And that will just help all parties be clear on what each side needs. And then, of course, you need to consider schools have a kind of special consideration with their public announcement of what's going to happen or what the plan is. You have a lot of constituents, as Emily touched upon earlier. You have to consider the regulators, the staff, the students, general public, alumni at a lot of schools would have concerns about some kinds of mergers and acquisitions. And we've seen schools where they put out a press release that something was happening, and their school Facebook page blew up with students who, kind of freaked out about what was going to happen and where were they going to go. And so that is something that you definitely want to think about and anticipate questions and concerns before you make an announcement, and then before you send those that information on to regulators. So all of that kind of ties in with the timing that you need to consider as you're drafting your LOI. Of course, most of these regulators, or most parties to a transaction won't want you to give specific names out when you are reaching out to the regulators to find out what needs to happen. So a lot of those calls will be blind calls, and that you can run into trouble there when you call an agency and say, what would happen if a school you approve did this? And they'll say, well, which school? So, then once you say, I'd rather not say, or it's a blind call, then they might give you an it depends answer. So you do run into that, but you can generally get an idea of the timing of those kinds of things. And it's very important when, even if it's not something specifically in the LOI, it's very important to consider who will be doing all these things for the transaction. Will seller be doing everything leading up to close, and then buyer will take everything will take over after? Well, that's kind of a nice idea, but that's not really how it works in these cases. A lot of times the buyer has to do a lot before close because the regulators want to see who's going to be taking over the school, and they want to learn about them before they're going to approve that change. And you definitely need to consider who's reaching out and coordinating that reach out so that both sides aren't calling the regulators simultaneously, or they're getting calls confused about what's happening. And you just want to keep a great relationship for the school with that regulator moving forward. One way we found that really helps with all of this is to keep simultaneous tracking documents. So both sides of a deal will kind of keep their own tracking documents, and then we can compare those and make sure everybody is on the same page. And as far as the diligence review, Emily touched on this earlier, and you really want to consider whether it will be a red flag review or you'll want details from every angle. So do you really just care about these, scary things that you might see when you look through files and you just want to jot notes down on those, or do you want to know in depth everything from a regulatory side? And then depending on what you want, that will determine how much time you need to consider in your letter of intent and how you want to word that condition to close that Emily mentioned previously in that letter. So I'd say that kind of covers it. One other thing to keep in mind is that these letters of intent often do go to some of the regulators. They want to see the letter, so it's just something to keep in mind. We've gotten around it. If somebody asks for it, there are certainly ways you can say, well, can we give you the terms without the letter if there's something that you don't want disclosed, but it's something to keep in mind as you move forward.
Katie, and this is Emily, that's a great point. I do want to just make a plug again for it's just a good, when you get to you're just about to sign an LOI, I recommend that you have your lawyer take a quick look at it before you sign so that we can just make sure that it's safe for third-party consumption. There could be things in there that could be harmful to you or that we know that regulators don't want to see in there. So, aside from cleaning up drafting or making sure that it terminates at some point in the future, we want to make sure that you just have a lawyer just take a quick look at it. Certainly it's mostly business terms, but making sure that it's safe for consumption by others.
Yep. Thank you, Emily. And now I'll let you run through our top 5 takeaways from this hour we've enjoyed together.
Yes. Okay, great. Well, thank you so much. So you'll see here, I'm really just trying to boil this down to maybe the top 5 things that I want all of you to take away from this presentation. Number 1 there in the blue is clock management. So that means don't wait until it's too late. I mean, it's hard to tell when is the right time to pursue or close a transaction, but you don't want to wait until you're too far down the path where, your assets are decreasing in value or your enrollments are down, and it'll be tougher for you to negotiate a deal at that time. So sometimes it's a great time to pursue strategic partners when you're doing great, because you can get maximum value or, get a good arrangement or partnership in place. So I think, it takes a lot longer and it costs more than you think. I mean, I kind of am reminded of if anyone's ever remodeled their house, the contractor says just add dollars and days. Kind of a good rule of thumb. I mean, Aaron and I always try to be extremely efficient. I work in my lane and Aaron and Katie work in their lane. But there are third parties here. There are regulators. There are agencies that we cannot control. So while we've never had or seen any deal go perfectly, It's hard to predict what will happen, but just kind of build in a little bit of time for yourself so you don't run out of runway. And, transactions can take, they can take 3 to 6 months. They can take a couple of years if the regulators, drag you along. And so people are always surprised at how much longer it takes than you think. And so, again, the drivers there can be regulators. So they're kind of dictating the timeline as opposed to the parties. So point number 2 here, you'll see the LOI is just critical. It's a communications tool. It's literally getting everyone on the same page, okay? This is what we're going to accomplish, and we're going to do it together, and this is everyone's responsibilities. As Aaron pointed out, I think point 3 is you've got to consider regulatory when you're structuring a deal. If you set up a sub, are you going to blow the 2-year audited financials requirement? I mean, nobody wants growth restrictions if they can avoid it. So be smart in how you're structuring a deal, and at the LOI stage is the appropriate time to think about how you're going to put this thing together. Point number 4, working with advisors who know the industry, whether it's higher ed lawyers or accounting firms who specialize in this space, as well as people who have relationships and work regularly with ed or the state agencies and know the players well. I mean, that's always going to cut to your benefit.
And Emily, I'll jump in there.
Yeah.
I did mean to say earlier that it does really help to have someone on your team who has these great relationships with the regulators. And I mean, you all have listened to Aaron today. He's a smooth operator, so he's definitely a good person to have on your team, kind of helping move things to the top of the pile sometimes if necessary, or just helping move things along.
Yeah, and I would say, my takeaway from Katie's slides were, you've got to be strategic and organized when you're approaching regulators. Don't let them find out about your transaction from a Facebook post. Coordinate who's calling so that you don't have a bunch of people making calls and they're getting all kinds of conflicting information. They're not going to appreciate that. So be strategic, be organized, be timely. Make sure you understand if that approval is needed before or after closing, because that's going to be critical. No regulator wants to know that you already closed without them, and I assure you that's not going to end well for you. So the last thing I just want to say very quickly, and I realize we're out of time, is that, I hope this has become apparent to you during our presentation, but, I'm a corporate attorney by training, and I know what I need to do to bring the parties to the table and close on a scheduled closing date. Aaron and Katie are my regulatory experts, and I would not try to advise a client on a transaction without their help. It's just very difficult to be a strong corporate attorney with deep regulatory expertise, and the inverse is also true. So maybe it's point 4 on this chart, but make sure you're working with folks who understand the amount of time and work it takes to close a transaction, and people who can speak the lingo and engage with you on things like accreditation issues, Title IV, and growth restrictions. These things are unique to the education space, and I'll tell you, when I first started working on school deals 15 years ago, they sounded very foreign to my then general corporate ear. So, and I guess I want to make the comment that, it really just takes everyone rowing the boat together towards this closing date. We need to get everything in line. If the regulators are not, ready to issue their consents, or their boards are not meeting, and we've passed the 10-day window in that beginning of the month, then we're looking at the next month. Then the seller is griping about, carrying costs for another month. And the buyer is getting, a little short or impatient because they want to get in there and start operating and playing with their shiny new toy. So make sure your attorneys and accountants are well versed in this space. You'll just need a very organized team to get this across the goal line. So I'll now turn it over to Aaron to go over some resources and the Q&A part of our presentation. And thank you all so much for joining us today, and I hope this was helpful.
Thanks, Emily, and I appreciate it. Katie, I can't wait to go home and tell my family that someone referred to me as a smooth operator. I think they will find that extremely humorous, and my kids will no doubt object to that characterization. They frequently use very different adjectives. So we do have, for folks on the line, I'll get to the QA here quickly. I just want to point out we do have our blog, Regucation, where we write about various issues and things that pop up. It's free. It's on our website. You can see here, actually, we just recently, in advance of this webinar, wrote a little bit about mergers and acquisitions. And some of the things that are we discussed here today, we put there in a slightly different way. Also, again, I just want to emphasize that these webinars and the ones we've done in the past are all available available free and on demand on our website. I mean, this is just something we feel like is important to do for the higher ed community. Our other attorneys too, we're about 380 attorneys. It's a pretty big firm, and we've got labor and employment folks and cybersecurity folks and others who also do webinars. So you might find something else on the firm website that houses all of these things, something else that you find of interest. But certainly the higher ed series is there. We would love to know, as Emily mentioned, we mergers and acquisitions is complicated. You could do scores and scores of webinars on different little pieces of these transactions. We've just touched on letters of intent today. We'd like to know what else you'd like to hear about. We plan to do this series every year, but also we do webinars that aren't part of the series, just as one-offs, particularly when we think there are things happening that folks want to know about. So if there's some element when you do that survey at the end, if there's some piece of transactions you'd really like to hear about, let us know, and we can try to put together a webinar for you. Again, this is our thanks to you, just Emily and Katie's information here if you want to reach out to them. I joked last time this was me auditioning for the English role of English professor at the local high school. I have to think of something new. I actually saw that for those on the line who may know who Gordon Gee is. I thought this is me auditioning for the part of a young Gordon Gee. And this is our disclaimer. So let's go on to Q&A. We've got a couple of questions here, and I will, start with the first one. What multiple of EBITDA are you seeing as a purchase price, perhaps a range, and what drives up that multiple? Emily, I have thoughts, but what do you think? And Katie as well.
Well, I will, this is Emily here, and I'll lead off and then happily hand it over to the two of you to weigh in. So, of course, I mean, I think this will vary. This is a very lawyerly response, but it's going to vary very much, of course. The first thing is not everyone agrees on the definition of EBITDA, but so once the parties have agreed to that actual definition and what's going to go in and what's not going to go into EBITDA, I would say that in general, and of course this is going to be very specific, fact-specific to each institution, but I would say a normal, just kind of middle-of-the-road institution could be looking at 4 to 6 times EBITDA. I would say that the distressed institutions I see coming in at about 2 to 3 times EBITDA. And if you're going gangbusters, if you're just, doing great, I mean, and we have a lot of those clients and those types of institutions out there in a booming U.S. economy right now, you could see anywhere from 10 to 12 times EBITDA or, more if an international buyer is willing to pay more. So those are the general ranges that I've seen. But Aaron, please feel free to add to that.
No, I agree. And for those, I think most of the folks online probably know what EBITDA is. It's very typical, or at least historically has been the case that, and I really don't know so much about other industries, but certainly in the higher education space, it has often been the case that a multiple of EBITDA is the way that folks start to sort of first zero in on what a purchase price might be. And you can add to that real estate. So if you are, it doesn't matter, for-profit or nonprofit, if you have a real estate holdings, typically you would take that multiple and add to that the worth of that or the value of that real estate. And how you value that real estate, of course, is going to probably be subject to some debate. I completely agree with Emily, though. I mentioned at the outset that a lot of what I'm seeing right now, and we've been working on the last couple of years, are transactions involving institutions that have financial challenges. Sometimes they have great things to offer, resources, facilities, instructors and faculty, staff, curriculum, you name it. But for whatever reason, they're really struggling. These transactions can look very different, right? I mean, sometimes the buyer will just essentially acquire the institution and take on its debt, and there may not even be an affirmative purchase price. I've worked on 2 or 3 transactions in the last couple of years where a seller was actually paying a buyer. So in a sense, a reverse I don't want to use the word reverse merger because that's something else. But, in terms of the purchase price, it's going the other way. And folks may say, well, gosh, why on earth would a seller pay someone? Winding down an institution of higher education, particularly one that's been around a long time and may still be quite large, even if it's suffering financial challenges, if it has several thousand students, winding down an institution like that is very costly, and then you have all kinds of potential exposures and liabilities that may come about as a result of closing the institution, particularly if you're not able to keep it open until every single student has a chance to graduate or otherwise depart from the school. And it is not entirely unheard of in this day and age for institutions to say, we have looked at what it would cost us to operate this institution for 2 more years. And given our financial model and the directions of things, we think that's going to be several $1 million to complete an orderly teach out. And we're willing to pay if there's an institution down the street who thinks a merger would be of interest and would take us over and infuse capital and bring new resources to the table. We can pay them $1 million, which is less than it would cost us to teach out the school. So you've actually seen situations where not only is it not a multiple, but the seller's actually making the payment. So it's all over the map. But if you were talking about a healthy institution that was, for whatever reason, being acquired, and they had a strong regulatory presence, they didn't have a lot of issues or compliance concerns, their financial model seemed to be working, I agree with Emily, 4 to 6 plus whatever value is in the real estate, if any, that they hold. Let's see. And the next question is very similar. It's interesting. These are both questions from folks who obviously have been around mergers and acquisitions in this space. What multiples of net profit or gross tuition are schools bringing today? So in other words, that's another way of getting at how would a potential buyer come up with a purchase price that they think is reasonable for an institution. Emily, do you want to take a shot at that one as well?
Sure, and I mean, it's a fair question. I mean, and again, EBITDA, net profit, gross tuition, these are all metrics by which parties can calculate a fair value or purchase price or, transaction price for a particular program or school. I've seen people kind of shy away from net profit or gross tuition just because of, what I was saying earlier about how it can be very seasonal and how it's difficult to kind of pinpoint valuation based on tuition alone without taking out, other things. I mean, so I've really seen people mainly stick to the EBITDA ranges. So I guess that would be my kind of ducking out or main reply, because I don't really see a lot of people using multiples of net profit, or at least certainly not buyers.
The other thing I'll add too is, I mentioned at the outset that we're seeing a fair amount of cross-sector acquisitions, right, where you've got a nonprofit that's acquiring a for-profit. And typically, with the result that the for-profit, it could still be operated and held out as a separate institution, but typically what that means, I mean, you could do it as a subsidiary. They may just acquire the assets. But without regard to how it's structured, typically nonprofits are restricted largely to acquiring things at fair market value. So, and there may be state laws or others around that. So one of the things to keep in mind is when we're talking about how to value an institution here and you're talking about multiples, you're probably talking about the acquirer being an investor or another for-profit entity. If you have a nonprofit or a public entity that is acquiring a for-profit entity, the multiple concept probably doesn't work. Instead, what you're likely going to be doing is you're going to have some sort of third party do a fair market valuation, and your nonprofit's going to end up paying that fair market valuation. And that's all the questions we have. So I just want to thank everybody for joining in. Again, if you have, please fill out the survey if you got a minute. The on-demand recording and the materials will be available right there here. Probably the materials are already there. The on-demand recording will be around, within the hour. And if you have future topics you'd like to see in the area of M&A, please let us know. Finally, once again, I'll just note that our next webinar, which comes about in October, is going to be about the upcoming midterm elections and the impact of those elections. We'll do a little crystal ball work and thinking about their impact on education. I think it'll be very interesting and encourage folks to join in. So thanks all and have a great day. And stay safe if you're on the East Coast in the Carolinas or Georgia.